This program is brought to you by Emory University.
It's my pleasure to welcome Jana Edmondson Cooper to be the leader of this lunch session. Jana is the bilingual staff attorney in the Macon Regional Field Office of Georgia Legal Services. As a graduate of Mississippi College School of Law, Ms. Edmondson Cooper draws upon her prior experience as a professional legal interpreter, and her experience as an attorney to provide bilingual legal services to low-income individuals. Ms. Edmondson Cooper is also a persistent advocate for improving language services for limited English proficient individuals, especially in legal settings. In 2013, she was appointed to the Supreme Court of Georgia Commission on Interpreters, which sets the rules, policies, and procedures for regulating the quality of court interpreters in the state of Georgia. So we obviously couldn't ask for a better instructor on today's critical issue of language access. As you can see, Ms. Edmondson Cooper has two guests with her, and I will let her introduce them. Thank you. Sorry, I forgot about the structure we're using. So I also want to introduce Pilar Archila, who is a certified interpreter, works a lot in Middle Georgia, particularly in Macon, in legal settings as well as other settings where interpretation is necessary. So thank you all for joining us.
Buenas tardes.
Good afternoon.
Entonces, yo voy a usar Pilar para asistirme con comunicarse con ustedes.
I'm going to need Pilar to help me to communicate with all of you.
Y primero vamos a tener la oportunidad para tener una discusión con la sonoría Melody H. Clayton.
We're going to have to do something to make a decision with Your Honor, Melanie H. Clayton.
En 1992, Melody H. Clayton fue elegido a un juez de tribunal estatal en el Distrito Judicial del Condado de Cobb.
In 1992, Melanie H. Clayton was elected a state court judge in the Cobb County Judicial District.
Ella derrotó a 3 oponentes y fue reelegido en 1996, 2000, 2004, 2008 y 2012.
She defeated 3 opponents and was re-elected in 2096, 2000, 2004, 2008, and 2012.
Sin oposición.
Without opposition.
Preside los casos civiles y penales de delitos menores.
She presides over misdemeanor, criminal, and civil cases.
Además, juez Clayton preside el Tribunal DUI en el Condado de Cobb, que es un tribunal de resolución de cuentas por los acusados con múltiples cargos de DUI.
Judge Clayton is over the DUI, driving under the influence, court in Cobb County, and accountability court for defendants with multiple DUIs.
Juez Clayton es ampliamente involucrado en la comunidad legal, incluyendo pero no limitado a servir previamente como presidente del Consejo de Jueces de los Tribunales Estatales.
Judge Clayton is extensively involved in the legal community, including, but not limited, to previously serving as president of the Council to State Court Judges, where she currently serves as chair of the Council.
En 2012, Juez Clayton fue nombrada a la Corte Suprema de Georgia Comisión de Intérpretes, donde actualmente sirve como presidente del panel de causa probable, que repasa e investiga las quejas en contra de los intérpretes lesbianas por la comisión.
In 2012, Judge Clayton was appointed to the Supreme Court of Georgia Commission of Interpreters, where she currently serves as the chair of the commission. Probable cause panel, which reviews and investigates
las quejas en contra de los intérpretes que son iniciados por la comisión y forman una recomendación al panel disciplinario en cuanto si se debe tener una audiencia.
Investigate complaints and review about interpreters licensed by the commission and makes a recommendation to the disciplinary panel as to whether to hold a hearing.
Por favor, un aplauso para la sonoría Melody H. Clayton.
Let's applaud Ms. Judge Melanie Clayton.
Thank you, Ms. Edmondson Cooper. I very much appreciate that kind invitation. Good afternoon, everyone. I'm here to say a few words of welcome and greeting from the Georgia Commission on Interpreters. I am representing Justice Keith Blackwell, who is out of town and unavailable to come today. And I think I was chosen to replace him for essentially 3 reasons. The first is I think that I am a judge. Well, no, I know I'm a judge, but I think that's one of the I think that's one of the reasons I was chosen. Since he's a judge, they decided to send a judge. And I'm the state court representative on the commission. And second, I am what might be tactfully referred to as a seasoned lawyer, also what I saw referred to in an evaluation yesterday as a woman of a certain age. And so I can give you a little bit of historical perspective on how far we have come in this area. We have a good way to go, and I know there's a lot of room for improvement, and there will never be a perfect system. We are, after all human. But I have been practicing law for over 34 years, and during all of that time, at least a part of my practice has been criminal work. At the beginning of my practice, we had very few people in my county who did not speak English. Really not that many people in Georgia who were interacting with the court system. And we had essentially no professional interpreters of any kind. We used whatever resources we could, sometimes family members, defendants, family members, witnesses, family members, witnesses to interpret for the defendant. As horrible as it sounds, victims of domestic violence interpreting what the defendant was saying. Deputy sheriffs interpreting for us. Whoever we could find to interpret, because we wanted to do the best we could, and we had almost nothing. Sometimes it worked better than others, but sometimes I can tell you that I remember at least 3 cases in my court after I became a judge in the early years where the prosecutor just finally gave up and dismissed the cases against the defendants in misdemeanor cases because we could not find interpreters who spoke the language that the defendant spoke. We just could not communicate with the defendant at all. And they decided, well, these are misdemeanor cases and we just can't do anything about it, and they dismissed the cases. Now, in one case, this is before I became a judge, so I've been a judge now, if you do the math. I've been a judge almost 22 years, so longer ago than that. We had one case in Cobb County where a man was charged with rape, and he was not a native English speaker, but his lawyer thought that he understood him. And there was no interpreter for him, but he thought he understood him. He thought he understood what he was saying. And what he was saying was, I didn't do it. I didn't do it. It was not me. I didn't do it. I didn't do it. So they went to trial on a rape case with him saying, I didn't do it. The victim of the case, when asked, do you see the man who raped you in the courtroom, said, yes, that's him right over there. As the trial went on, and the guy got more and more and more agitated about how I didn't do it, it's not me. They finally figured out that the sheriff had mixed up 2 defendants in the jail. This was a man with a similar name. This man was not even the man that was charged with rape. Because we did not have an interpreter, this man went to trial and could have been convicted. Luckily, he was not convicted because they did figure it out during the trial of the case. But two huge injustices happened, at least. One is this man was held in jail on a rape charge for a long period of time before going to trial, when he wasn't even charged with rape. And two, the district attorney's case was destroyed against the person that actually was charged with rape because the victim had sat under oath in court and identified the wrong man as the rapist in the case. That was then. Fortunately, things are better now. We have the Commission on Interpreters here. We have a method for designating interpreters, for recruiting interpreters who we hold to standards and qualifications. We require training, we require continuing education, and we are raising awareness. We're raising awareness among attorneys, among judges, about the duties that they have to get the things done that they need to do to make sure that people of limited English proficiency get the justice that they deserve when they come into court. The third reason I think that I was chosen to come is because, as you heard in my introduction, I am involved in the disciplinary process for interpreters. The Georgia Commission on Interpreter Rules and the Code of Professional Responsibility are parts of the handouts on Ms. Edmondson Cooper's part of the materials. And they're full of information. And I just want to touch on one thing, and that is the disciplinary process. Very quickly, Rule 4 talks about the discipline of interpreters. And we employ, I'll just tell you, we employ basically a multi-step process. It begins with the filing of a complaint. The complaint is referred to the probable cause panel, which I chair currently, and we determine whether probable cause exists to believe that the interpreter has violated the Code of Professional Responsibility. And if so, we refer it on to the hearing panel. At that point, the interpreter has the right to a hearing, has the right to counsel, and they go on to have a determination. All of this is confidential, and nothing is made public except for the final determination. The proceedings and the records are never made public, but the final determination is made public. And where no probable cause is found, even that is not made public except on the request of the interpreter. Now, we hope you'll never have to use that process, but we just want people to know that it exists. We want people to know that we are really there for many, many reasons. We're there if you need us for anything. We're a resource on anything that has to do with interpreters in the justice system in Georgia. Unfortunately, we don't have interpreters in every language. We're working on it. Spanish is the one we're best in. If you need to get in touch with us, Google Georgia Commission on Interpreters, and you'll be taken directly to the website, and you can contact the staff and go from there. So again, greetings on behalf of the Commission, and thank you very much for having us.
Gracias, Juez Clayton. Yo necesito 4 voluntarios, por favor,
I need 4 volunteers, please.
excepto las víctimas también. excepten las víctimas también.
And victims also.
4 voluntarios.
4.
Ok. Sí, señora, en la chaqueta negra. ¿Voluntarios o víctimas? Sí, señor.
One right over
Aquí,
here.
en el suéter gris, por favor. Vengan a la frente, por favor.
Come this
Sí,
way.
señor. Ajá. Ok, tenemos 3.
We have 3.
Uno más.
One more.
Ok.
Okay.
Vamos a hacer un ejercicio con respecto al modo de interpretación consecutivo.
We're going to do an exercise, and we're going to do consecutive interpreting.
Go ahead. At about 8:15 p.m., a red sedan with a spoiler, maybe a 2000 Camry, southbound, approached the intersection of Peachtree Circle and Walnut Street. There was a stop sign, I think, but the driver did not stop. Then she turned and sped away. I could just make out her license plate. I believe it was AKJ0603.
Y ahora el intérprete va a hablar o va a decir lo que él escucha.
Right now, we have our interpreter here. He's going to tell us what he said.
I have no idea what he just said.
File a complaint.
Okay. State what you said again.
At about 8:15 p.m., a red sedan with a spoiler, maybe a 2000 Camry, southbound, approached the intersection of Peachtree Circle and Walnut Street. There was a stop sign, I think, but the driver did not stop. Then she turned and sped away. I could just make out her license plate. I believe it was AKJ0603.
¿Hay alguien en la audiencia que puede repetir lo que escuche?
Is there anyone here in the audience that can repeat what he just said?
Una parte está bien. Una parte, ¿no?
Or at least some parts of what he said?
Sí.
There was a spoiler, somebody sped away, license plate begins with 837.
Okay, excelente. Okay, señora. Gracias.
De nada.
Thank you. Thank you.
My income varies a great deal. I can earn $1,416 a month, but some months I only earn $893. It all depends on how much work I can get. Last year, I made $32,000, but with the car payment and rent, insurance of different sorts and food, child care, utilities, transportation, school tuition, clinic bills of $4,000, you know, I'm lucky if I can put $60 to $70 in the bank a month.
my income varies. My income varies on a monthly basis. I'm lucky if I can make put into the bank about $62. There's a lot of cost, including tuition, transportation, utilities. Something about 4,000 at one point, I think. She's having a difficult time making ends meet. That's my communication.
Gracias. Un aplauso, por favor. Thank you. So, como ustedes pueden ver, es muy difícil para servir como un intérprete.
As you can see, it's very difficult to be an interpreter.
Hay muchos detalles que es muy importante a un caso.
There is a lot of details that are very important in every case.
Y los intérpretes profesionales, ellos no tienen la oportunidad para proporcionar un sumario de los detalles.
A professional interpreter, we don't have the opportunity to have a summary of what's going on.
¿Quién en el corte puedo entender sin la intérprete?
Who can understand without an interpreter here?
Otra vez, me llamo Jana Edmondson Cooper y soy una abogada bilingüe con el programa de servicios legales de Georgia.
Once again, my name is Jana L. Cooper, and I'm an attorney, a bilingual attorney in the state of Georgia.
Y mucho gusto para la invitación para hablar con ustedes esta tarde.
And it's very nice talking to you this afternoon.
En este momento vamos a hablar sobre el profesionalismo y el acceso al idioma.
At this moment, we're going to talk about the access of the language.
Este mapa indica, con respecto al 1990 a 2010,
This map shows from 1990 to 2010
el crecimiento de población de LP en los Estados Unidos.
the growth of the LP in United States.
Y los estados azules indican una disminución del crecimiento de la población.
I'm sorry, the blue states what?
Los estados azules indican una disminución en el crecimiento
The
de la
blue
población.
states shows a decline in the growth.
Los estados amarillos indican 1 a 100% de un crecimiento.
The yellow states shows 1 to 100% growth in the United States.
Y los estados de naranja indican un crecimiento de 101 a 200%.
The orange states shows a growth of 101 to 200% of growth.
Y al final, los estados negros indican un crecimiento más de 201%.
And the black states show more than 2001% of growth or greater.
201.
201, I'm sorry.
Y ustedes pueden ver que Georgia es un estado negro.
You can see Georgia is a black state.
Y el crecimiento aquí durante ese periodo fue 396%.
And the growth in that period was 396%.
De 1990 a 2000, la población nacional creció 800% en el área de sudoeste y sudoeste en los Estados Unidos.
You want me to repeat that? No. They can read it.
Los individuos de LP representaron 25.2 millones o 9% de la población nacional que tiene más de 5 años. Por favor, repite eso, por favor.
In 2010, LEP individuals accounted for 25.2 million, or 9%, of the U.S. population over the age of 5.
Los individuos que hablan español representaron a 66% de la población total de LP.
Do you want me to? Spanish-speaking LEP individuals accounted for 66% of the total U.S. LEP population.
Los idiomas hablan más frecuentemente fue el español, el chino, el vietnamita, coreano y el tagalog.
Top 5 languages: Spanish, Chinese, Vietnamese, Korean, and Tagalog.
Los idiomas sexto a décimo incluyen el ruso, el criollo francés, el árabe, el portugués y los idiomas africanos.
6th to 10th more common languages: Russian, French, Creole, Arabic, Portuguese, and African languages.
Y los destinos tradicionales más comunes para las personas que hablan otro idioma fue el California, Texas, Nueva York, Florida y Illinois, y New Jersey.
The top states or traditional destinations, with people that speak another language, is California, Texas, New York, Florida, Illinois, and New Jersey.
And how many people were wondering how long I was going to do this entire presentation with the interpreter? How many of you are tired of concentrating on what I'm saying and then waiting for her to have to relay for what was not on the screen? It's a little bit of fatigue. So think about her, and Pilar is having to do it. And for those of you who are bilingual and you already knew what was being said, you were still waiting for Pilar to do the interpretation. And the reason that I wanted to start it off that way is to, one, demonstrate that it requires much more than just being bilingual to serve as an interpreter. Being an interpreter is a high-level skill job. And it's thanks to people like Pilar who take the time to become trained and be professional that are members of our society who don't speak English as their first language are able to have meaningful access to our justice system. So please give a hand once again for Pilar, please. And I want to ask Pilar, when you are working in a court setting, are you always by yourself or do you ever work with other interpreters?
I have worked with several interpreters.
Okay, and what would be a reason as to why you wouldn't work by yourself?
Sometimes they ask for a different interpreter for the defendant, for the witness. So in some cases, they request more than one interpreter. Even though we're impartial. We're never on anybody's side. I could be an interpreter for both, and I have done it before. But sometimes they request more than one interpreter.
And how long will you interpret at a time, in terms of time periods, before you need a break?
I have done an hour, 2 hours, and one time we had a trial that lasted like 8 hours straight and basically almost with no break. But that is unusual. Usually the judge give us time to take breaks.
And I want her to share that information with you all because there's something very real, something called interpreter fatigue, where when you are interpreting and you're going in and out of different languages and you're paying attention to the detail, we had that exercise in the beginning. So just imagine if someone was giving their testimony and the interpreter paraphrased or left out certain things, how detrimental that could be to a case. And Pilar mentioned something very, very important, that an interpreter is a neutral. They are not on the side of the defendant. They're not a side on the plaintiff. They are appointed by the court. And here in Georgia, any LEP, and I've been using that term, limited English proficient, to refer to individuals who have a limited or no ability to communicate in English, that would be reading, writing, or even spoken, that every LEP litigant and witness in the state of Georgia has the right to a court-appointed interpreter in criminal and civil cases. And a lot of attorneys aren't aware of that. A lot of courts aren't aware of that. We have a Supreme Court case, Ling versus State, that talks about that there is this right and there is a federal obligation for state courts to provide interpreters as needed in these types of cases. And what we're talking about in terms of professionalism today, there is a significant amount of guidance for state courts in this area of language access and providing meaningful access to litigants. But what I want to talk with you all about today in this topic of professionalism is about the lack of guidance that there is for attorneys. And so in speaking about the significant amount Oh, can you guys hear me? I'm sorry. Can you all hear me in the back? Okay, I'm sorry. In talking about state efforts, there have been a number of state efforts, and I'll go through just so we can get an idea of the type of guidance federally state courts have had in terms of providing language access in state courts. So I'll go down and I'll kind of start in the beginning. Washington, which has a non-unified court system like Georgia here, they approved a model language access plan through their administrative office of the courts. And just like Georgia, because they are a non-unified system, they can't force their courts to take on that plan, but it did serve as a model so that state courts could begin to assess the need for language access and develop their own plans for the court to ensure that they had a protocol, a formal protocol in place that allowed them to provide those services there. In 2010, U.S. Assistant Attorney General Thomas E. Perez, he issued a letter to all chief justices and administrative officers of the courts clarifying courts' obligations to provide language access under Title VI. And Title VI is Title VI of the Civil Rights Act of 1964, which in a nutshell states that any recipient of federal funding has an obligation to ensure that their services are available to limited English proficient individuals and that they cannot discriminate on the basis of race, gender, national origin, that's where language comes under, or the other protected classes. In June 2011, the Department of Justice and the Colorado Judicial Department entered into an agreement to settle a civil rights investigation. And that investigation arose after there was a Title VI complaint stating that the court had not been providing language access in all proceedings and court operations. And in March 2012, the U.S. Department of Justice, they reached an agreement, and they are now beginning to implement that plan to make sure that LEP litigants and witnesses do have meaningful access to the courts. In July of 2012, the Rhode Island Supreme Court, similarly to Colorado, entered into an agreement with the Department of Justice after a complaint had been filed. Very similar allegations in terms of LEP individuals who are not able to have meaningful access to the courts. And most recently, in May of 2013, just last year, the U.S. DOJ issued a letter to the Judicial Council of California. And most people, when I say California, they're surprised because they think California is so progressive, and they have one of the largest diverse populations in the state, but they too were having issues and had a complaint issued against them. And so specifically, the letter found that there were several policies, practices, and procedures regarding the provision of language assistance services in Los Angeles Superior Courts that appear to be inconsistent with Title VI of the Civil Rights Act of 1964 and its implementing regulations. And so in thinking about that and setting the backdrop, so this is what's been going on for about the past 5 years or so around the country. I want to bring it back home to Georgia and circle back around to something that Judge Clayton mentioned, which is even though it's not perfect, Georgia has really made a lot of leading steps towards language access. We have a Supreme Court rule governing use of interpreters that was established in 2001. In 2003, the Commission on Interpreters was established to help further this initiative. And what is really important is that in 2011, those rules were amended to include a general rule, which made it very explicit that the right to language access was not just in criminal cases, but in civil cases as well. And I believe, Judge Clayton, you mentioned about Ling v. State, which was a Supreme Court case in 2010. But before Ling, we also had guidance from the court in another case, Ramos v. Terry. And so when you look at these cases of Ramos and Ling and our rule on use of interpreters, which is in your book, so that you can have it for reference, the establishment of the commission and the commission's continued work, Georgia is really intentional and committed to making strides to make sure that limited English proficient individuals have meaningful access to our courts. And it's something that is going to take time to figure out what works best, because what works well in Atlanta doesn't necessarily work well in Dublin or Vidalia or someplace else. And so we have to take a case-by-case approach to find what it is. In addition to the state guidance, that the federal guidance that states were receiving, in 2012, the ABA also issued the standards for language access in courts. Now, while this is not persuasive to the states, it was very helpful in providing guidance to the states in figuring out what is this thing about language access. Don't just tell me what the challenges are, tell me how do we do this. And lastly, in 2013, the National Center for State Courts issued a compilation of years of research and meetings in their national call to action. And I don't believe that was too voluminous to put in your materials, but if you Google or go to the National Center for State Courts website, you can actually pull down that document, which has great guidelines. Okay. So now moving into professionalism here. Currently, 51 jurisdictions currently adopt the ABA model rules in some form. Georgia, pretty much all of our rules, they look just like the model rules. We have a few comments that differ here and there, but for the most part, we do adopt the model rules just like the other jurisdictions in some part. However, there's very little guidance in the model rules, in Georgia as well, specifically speaking about how does the professional responsibility of an attorney, what does that look like when you're representing a litigant who is limited English proficient, or a litigant who is deaf and hard of hearing, or DHH, or if you have a witness that you're working with that is LEP or is DHH, what does that look like? And so that's what we're going to talk about a little bit today. Because what we're seeing across the country is that there has been an increase in disciplinary action regarding language access and attorney professional responsibility. For example, the use of bilingual paralegals or other legal assistants without due regard for unauthorized practice of law or confidentiality. So we want to think about these things when we're representing LEP clients to ensure that we are being careful and fulfilling our ethical responsibilities. And I hope nobody in here paid someone to take their ethics test. So again, going around, just to provide a little bit of perspective, that these challenges are not unique to Georgia, and I believe that this should be in your material, so I'm not going to go through each and every one. But in New York in 1995, they issued a disciplinary decision that spoke about where they found a lawyer who represents a client with whom direct communications cannot be maintained in a mutually understood language must evaluate the need for a qualified interpreter service and take steps to secure the services of the interpreter when needed for effective lawyer-client communications, to provide competent and zealous representation, preserve client confidences, and avoid unlawful discrimination or prejudice in the practice of law. And of course, when we talk about these things, it's much easier said than done, and we're going to talk about the practicality. We always have, the perfect way that we think things should go, but life steps in, and it's not always so easy for us to do it perfectly, but we're not looking for perfect, we're just looking for due diligence and good effort. In Utah, they had a similar opinion from 1996 where they stated an attorney need not have any personal knowledge of language skills relating to language ability of the client. It is necessary, however, for an attorney to be able to communicate adequately with the client. And we're going to talk about what does that mean, adequately. Therefore, consideration should be given to language impediments that will materially affect the attorney's ability to communicate adequately in the specific circumstances of the client's case. The method by which how that will be done will depend upon the circumstances of each situation. So again, we're looking at it at a case-by-case basis. It's not cookie cutter for every situation. And California had a number of ones, but I really want to get to this one here from 1984, where they talk about any matter which requires client understanding, the attorney must take all reasonable steps to ensure the client comprehends the legal concepts involved in the advice given, irrespective of the mode of communication used. And so if you're in looking at these opinions, is anyone hearing a theme that each of these disciplinary boards keeps talking about in terms of respective rules of attorney professional responsibility? Anyone picking up on a theme for any particular rule?
Jenna.
If there's one rule that we keep hearing about, which one do you think it would be? Not yet? Okay, we'll keep going, see if we find one. Yes, attorney-client communications. There's one. Any other ones stick out? Yes.
The attorney has to take steps towards ensuring someone says this is the interpretation or communication.
Okay. Anybody else? Okay. In Michigan, I thought this one was very, very apropos for this session here. Basically, there was a client, and the client spoke Arabic, the attorney did not. And the complaint charged that the client and that the attorney did not explain a settlement document to the client adequately. And even though the respondent failed to explain, or according to the count, failed to explain the matter to the extent reasonably necessary to permit the client to inform decisions about representation, and they found that was a violation. And so even though here the actual decision didn't find that there was a violation, this just goes to show that these are coming up in complaints. And we're going to talk about here in Georgia what the disciplinary board is starting to see more and more of in terms of clients who have limited ability to communicate in English. This one, the Washington attorney, and this is one of the more recent ones, voluntarily resigned in lieu of disbarment for completely delegating all interactions with Russian-speaking clients to Russian-speaking non-lawyers and failing to supervise the non-lawyers, among other ethical violations. Which ethical violations do you think that they're referring to? Anyone? Yes, ma'am, in the back. Unauthorized practice of law. What else? Just based on that small snippet. Yes. Absolutely, the communication. And supervising subordinates. And we're going to talk about that as well. Proper supervision. Last year, North Carolina proposed, there was a proposed opinion that kind of got taken off the table because back in 2012, the U.S. Department of Justice issued a letter admonishing the North Carolina Administrative Office of the Courts for not being compliant with Title VI. And there are so many poignant parts of that letter, but what really stood out in particular was a line from Assistant Attorney General Thomas E. Perez that said, "Fiscal restraints are not an excuse for noncompliance with Title VI." Because like many courts across the country, including here in Georgia, North Carolina said that they were having fiscal constraints and it was hard for them to meet the budget and be able to provide an interpreter in every single case. But specifically to North Carolina, in the investigation that the DOJ had, they found that in order for them to be what we considered compliant with Title VI, it only would have been 3% of their total budget. And so what was stressed there was that fiscal constraints, even though they're very real, they're not an excuse for noncompliance. And so we had to figure out a way to address these challenges and not just say, "Oh, sorry, we can't afford it, we can't pay for it, you have to bring your own." And so as I mentioned, based on that letter, the proposed ethics opinion has currently been suspended until North Carolina has an opportunity to implement the changes that they are making based on the corrective actions that were requested in that letter in March of 2012. So what about Georgia? We've been hearing about everybody else, but what is going on here at home? There has been an increase in disciplinary issues involving immigration clients. One of the biggest ones includes attorneys who advertise that Spanish is spoken here, se habla español, to attract limited English proficient clients, but then when the client enters into an agreement, the attorney really isn't able to communicate adequately with that client. And so I get a lot of clients who come to Georgia Legal Services Program after the fact. They've already been dealing with a private attorney, and I ask what happens. They say, "Oh yeah, I paid the retainer, and then I never heard from the attorney again." And now they're at Georgia Legal Services because they don't have any more resources to be able to go out and find another private attorney. So this gets into advertisement in terms of our professional responsibility in terms of advertisement and the skills that attorneys are putting out there to attract limited English proficient clients, but then are not able to fulfill the obligations to that client. And it also gets into the breach of contract issue as well, where they're accepting retainer agreements, they enter into an agreement, but then the work isn't done because there's lack of communication or no communication whatsoever, which is exacerbated by that language barrier. So as I mentioned earlier, which model rules? Last year in October, I worked with a group of advocates in different parts of the country, and we provided a letter to the ABA asking for consideration of providing or adding commentary to the model rules to specifically address these particular concerns and to give attorneys more specific guidance and on par with all the guidance that state courts have on language access. And in speaking about those rules, we thought we could have, gone through all of them, but we want to be concise and really go to the ones that we thought were the most pertinent, and that's what I want to share with you all now. And so before I go in, and we don't have to give the numbers, but we talked about first, of course, communication, that's Rule 1.4. What may be some other rules that come into play when you're representing an LEP litigant? Just you can throw them out there. With regards to what? Anybody? I'm sorry? Confidentiality, absolutely. Rule 1.6, what else? Diligence, absolutely. 1.7, that gets into your competency. What else? So we have confidentiality, communication, your diligence, which is included in your competency. What else? Okay. Supervision. Any others?
Updating the client's development in the case.
And that would go towards your communication, making sure that you're adequately able to communicate. Okay. So the first three rules that we discussed in our letter that we thought really needed some attention and would benefit, and attorneys would benefit from having commentary added to the commentary of these particular rules. First was Rule 1.1, talking about terminology, because Rule 1.0 defines the meaning of many frequently used terms throughout the model rules. Specifically, we talked about adding commentary to the definitions of confirmed in writing, informed consent. In order for an attorney to fulfill an obligation articulated by each of these terms, it is imperative that they're able to communicate effectively with the client. And so we ask that those particular terms, that there be some commentary added there. Because if the attorney does not adequately communicate with the client in that regard, then the client can't. How can a client give informed consent if they don't really understand what has been explained to them? And so that we started off with speaking about terminology. We then moved into Rule 1.1, competence, because it's very clear. That's one of the first things that's drilled into your head. If not as a first-year practitioner, you probably start hearing about it when you take your ethics course in law school, that we have an ethical duty to provide competent representation. And competent representation requires legal knowledge, analysis, skill, thoroughness, preparation, which is all of that is necessary in order to adequately represent your client. However, if you are not able to understand your client, then how are you able to analyze the facts of the case? First, you're not able to have full understanding of the facts. If you don't have full understanding of the facts, then how do you analyze that? How do you apply those facts to the law? And if you're unable to do a legal analysis, then how can you provide a consultation or legal representation to your client? And so we thought it would be beneficial and it would behoove the ABA to add commentary to Rule 1.1 regarding language access. The third rule, 1.4, communication, that's really the big one because all of these other rules hinge on being able to have adequate communication. And we keep talking about what is adequate, what does that mean? And specifically, the rule says that attorneys have an ethical obligation, inter alia, to explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding their representation. The client should have sufficient information to participate intelligently in decisions concerning the objectives of the representation and the means by which they are to be pursued to the extent the client is willing to do so. And so in talking about communication, I think is helpful, I have two scenarios. How do you identify the need for an interpreter? If you're working with a client, how do we know it's just not a matter of just limited English, but they really understand everything that is going on that is permissible enough that you don't need an interpreter? And how do you gauge when you really do? So this is our first fact pattern. Maria contacts your office after she began to suspect that a former professor was stalking her, but not at Emory. After completing the required phone intake, Maria came into your office for an initial interview. You explained the varying levels of assistance you could possibly provide as her attorney, including contacting the university where the stalker works, and she still attends. You also explained the pros and cons of applying for a stalking order here in Georgia, and give Maria a brochure on the legal process. At the end of the meeting, you provide Maria with a retainer agreement for her consideration and tell her to call you with any questions. She smiles and says enthusiastically, "Thank you very much." 1 week later, Maria contacted you to find out if you had contacted the university yet and to find out the status of her petition for a stalking order. One small thing, you haven't yet gotten the retainer back from Maria. Maria has severe hearing loss and signs in ASL, American Sign Language. In reading or hearing this, what may have been some red flags that Maria obviously didn't understand what may have gone on in your consultation? Right. So this woman, she said clearly she left that office thinking that she had hired an attorney, that it was done. So somewhere in that consultation, as the attorney was explaining what possible assistance the attorney could provide, Maria understood that to mean this is what I'm going to do for you, or these are our next steps. What is another sign that possibly Maria didn't really understand? Yes, ma'am. She didn't ask any questions. That's really huge. We want to pay attention to the exchange between the client and the attorney. And sometimes with individuals who have hearing loss or are completely deaf, they may be able to understand, and even if they lip read, but those who are experts in the deaf community, that lip reading is highly ineffective. And so even with passing notes back and forth or trying to write as an alternative to having a certified ASL interpreter who can facilitate and assist you with communication. Yes, ma'am.
Just a question. How could she do a phone intake and not reveal that she was hard of hearing? She would want that specific device for users.
Right.
Would that not be an initial red flag walking in?
Right, that would be a red flag. Now, the nuances that we didn't get into in the hypothetical, some offices, maybe not, and this would probably be more in a private office or something, but they do have video capabilities for intake specifically for those who are deaf and hard of hearing, where you can visually do the intake while you were on the phone. So that could have happened here. I specifically didn't put that in there just to keep it a little bit more ambiguous, but that is an option that is available that law offices use and a lot of legal aid offices use to ensure that they're able to communicate with individuals who may have hearing impairments. Any other questions? Okay. So the big red flag is when Maria calls back and says, "Oh yeah, what's going on with my case?" And she hasn't sent the retainer. Another red flag is the fact that we sent off a client with a retainer. Who's going to explain to her what the retainer says? How is she supposed to know what it says? And the fact that you haven't gotten it back yet. So those are just a few red flags. Lack of communication with the client. We don't hear any exchange with the client asking questions. And then you're getting that phone call, which is essentially like getting a call from a client saying, "Yeah, so what's going on with my case?" As if you have already taken it on and agreed to represent that individual. Okay, our second hypothetical. Nguyen was referred to you by a local immigration organization. He speaks Vietnamese and some English. He has been served with a lease termination notice from his apartment complex. He visits you for a consultation. You ask him what brings him in to see you. He promptly gives you the lease termination notice. After you look up from reading it, he asks you, "Can you help me?" You proceed to explain Nguyen his legal options, being careful to pause and ask clarifying questions. He answers yes and nods his head during the course of your conversation. You ask if he has any further questions of you once you're done, and he says no. You send him home with a retainer to consider. You don't hear from Nguyen again, despite learning from your colleague at the local immigration organization that Nguyen is in dire need of legal representation and is looking for an attorney. And let's just assume it wasn't the amount that you were billing him in the retainer. Red flags. That an interpreter was more likely than not needed for this interaction between Nguyen and yourself. He always says yes or no. That is a huge red flag when working with clients who are limited English proficient. Yes and no does not tell you as the attorney whether they truly understand and comprehend what is being discussed in that meeting. And so you want to be very careful to stay away from open-ended questions that can just be simply answered a yes or a no. You want your client to explain it. Something that I always employ with my own clients. And when I do ask them, I say, do you understand? And they say yes. Okay, I'll say, well, please, share with me what your understanding is of what we just said. And usually 9 times out of 10, that works. Either they're able to explain it back to me, which gives me an indication of their comprehension of what we just discussed, or they're not. And then sometimes they'll say, oh, well, you know what, can you say it, can you explain it to me one more time? Another thing is to be very cognizant of cultural concerns. A lot of times, you're in a position of power. And in a lot of cultures, there's a high respect for individuals who are in a position of power. And so they may feel as though if questioning you might be disrespectful, or asking a question, or saying no. And so they just want the process to move as smoothly as possible. And so they're not inclined to really not be combative, but to ask a lot of questions, or to question what you say, or ask you to say, well, why is that? That is not a part of everyone's culture in terms of working with persons that they perceive to be in positions of authority. So you definitely want to be sensitive to that. Yes, ma'am.
All the examples that you've shown so far are consultations. In a consultation, you're not necessarily going to have an interpreter accessible to you. See what I'm saying? 'Cause that'll be all your consultations. If you charge like $150 per consultation, and somebody just randomly comes in for a consultation, you're not going to necessarily have an interpreter there for that. And the consultation is not in and of itself entertaining. That's just me listening to your story, giving you some advice. You see what I'm saying?
Right, that is correct. And when we say interpreter, so we've talked about getting court-appointed interpreters in court, but the term is someone who's qualified to provide interpreting. In this particular instance, that might be a bilingual staff person. That might be a paralegal who is assisting you with doing that. But you're not able to, but when you're looking at identifying the need, and the point of this is to identify if this particular client has language assistant needs that you need to be aware of. So not necessarily getting into the duty of providing an interpreter at the point of consultation, but learning to understand the red flags, or to understand and say, hey, there might be some challenges here, and these would need to be addressed for me to, if I do take this client on, for me to fully represent the client. Because of course, after the consultation, once they're retained, you're gonna sit down and have a more thorough meeting to make sure that you're understanding the legal challenges that they're facing. And at that point, you need to be able to adequately communicate with, at that point, your client. So we just want to make sure that we're understanding what may be some indicators that you should be along that line of thinking, to saying, okay, it looks like I'm going to need to make sure that this client has adequate language assistance. And that is going beyond the verbal. The retainer may need to get translated. The any other in the course of the representation, when you're going over pleadings that you are going to be filing with the court, how is the client going to make sure that they understand the complaint that you may file on their behalf, or the answer that they file on their behalf? If you get discovery back from opposing counsel, how do they understand those interrogatories? All of that is going into providing language assistance there. Will you translate everything? Will it be an oral translation there from your bilingual paralegal, or perhaps you have a bilingual staff attorney? In my office, I communicate with my clients. I don't have to hire an interpreter just to be able to have one-on-one conversations with them. However, when I am prepping them for a hearing, I do get an interpreter to prep them for a hearing for 2 main reasons. One, I can't be both their attorney and their interpreter. That raises a host of conflict of interest concerns, and it's physically just not possible for me to wear the hat of advocate and also wear the hat of interpreter. And we're going to get more into that when I get to Rule 1.7. But also, too, there may be individuals who have never communicated through an interpreter. And you don't want it to be the first time that they're having to communicate with one is the day that you get to court. There's more than likely already a lot of anxiety there with just, as lawyers, we go into court. Some of us like going into court. It's an enjoyable experience for us. But for a lot of folks, including some attorneys, it is not. And most of my clients are not excited about going to court. And so in order to have one less level of anxiety, if they can have some understanding of what it's going to be like to communicate through an interpreter, knowing that they should use short, simple sentences and phrases, that they need to take pauses, that they speak in the first person. It's almost as if you act as if the interpreter is not there. So they wouldn't, say, oh, well, tell her I said X, Y, and Z. They just speak in the first person to whomever the target is of their communication. All of those things help when you can prepare with having a professional interpreter that is there. Okay. So going forward, the additional rules that we talked about. How am I doing on time, Silas? Are we good? Okay. We talked about Rule 1.14, clients with diminished capacity. And I want to share with you what we put because I thought we were very careful. We definitely didn't want the community to think that we were saying that people with LEP have a diminished capacity. Being LEP, that's not a disability, so that's not what we were saying. But we were talking about people who have a diminished capacity or maybe a mental disability as defined by disability in the ADA. If they happen to be LEP, how does that particular rule intersect with an attorney's professional responsibility? And specifically what we shared was that where a client with diminished capacity for any reason is LEP or DHH, deaf or hard of hearing, it raises language access concerns and attorneys need guidance from the committee. Specifically, there's a lack of guidance in the comments concerning the duty to take protective action. Adding language access commentary to Model Rule 1.14 will provide clarity by providing guidance on taking protective action where the client's diminished capacity is exacerbated by the fact that they're limited English proficient. And so if you read Rule 1.14 in its entirety and you look at the commentary, it talks about the duty of an attorney to take protective action to ensure that that client's representation is adequate there. And so that's what we wanted to talk about. But how do you take protective action? And again, going back to Rule 1.4, if you cannot communicate adequately or properly with your client. And we gave a few what taking protective action would mean, including, translating relative pleadings or documents that are pertinent to the representation, interpretation of oral communication, so that everyone involved, the court, opposing counsel, whomever, they can make sure that everyone is on the same page and they understand what is going on. Someone had mentioned earlier Rule 1.6, confidentiality. And specifically in speaking about confidentiality, we generally know what happens if there's another person, not from your, if a third person is in the room with you and your client. What happens to the attorney-client privilege? It's demolished. It goes away. That does not count when we're speaking about interpreters. And in the Interpreter Code of Ethics that Judge Clayton mentioned earlier, Standard 10, Roman numeral 10, specifically talks about the fact that generally the presence of an interpreter does not destroy attorney-client privilege. And so if you bring in an interpreter for hearing prep or or whatever it may be, the fact that that interpreter is present while you are communicating with your client, that communication is still privileged. However, we do want to be cautious, and this points to why we want to use professional interpreters versus individuals who have not had any type of formal or professional training, because the interpreter, if they're unaware of their duty to maintain confidentiality, they may destroy the privilege. They may go out and share information that should not be shared. Another part of the rules that Judge Clayton talked about earlier with regards to professional responsibility for interpreters talks about the fact that they are not to discuss what goes on in a case or what goes on in the courtroom outside of that setting. They're also supposed to limit their contact with the parties or individuals in that case. And so this is when we're talking about Rule 1.6, if someone has not had that training, if they have not gone through the commission and learned about their ethical obligations as an interpreter, they may not know that they aren't allowed to go home and talk about it with their husband. Or we see, particularly in cases of more rare languages, Judge Clayton mentioned that we have a number of languages that are tested through the commission, but we have quite a few that are not. And in those more rare languages, it is sometimes necessary to use a person of interpreter who has not been trained. And we have protocols in place for that and instructions for the court in those limited circumstances after due diligence has been done to try and find someone who has been professionally trained. But when you get into more rare languages, particularly if it's an indigenous community, you run into the issue of possibly the interpreter knowing personally one of the parties. And then what happens, because now you have to think about impartiality. Are they able to maintain impartiality when they may have a personal or otherwise close connection with a member? And so that's what we asked the ABA Committee on Professional Responsibility to address in the model rules with regards to confidentiality and what that looks like when you're working with an individual who is a litigant or possibly a witness. Just bringing more awareness for attorneys to be cognizant about the risk of confidentiality being breached is greater when you don't use someone with professional training in interpretation. Lastly, Rule 1.7, conflict of interest. And we were talking about that earlier with regard to me saying it's really physically impossible for me to go in court and be a competent, zealous advocate for my client and then also be his or her interpreter. Are there any bilingual attorneys in the room? Okay. Have you heard, and whether it was you or someone else, we don't have to put you on the spot, but raise your hand if you have heard of bilingual attorneys being asked to interpret for their clients in court, whether it was you or someone you know, or if you have observed that happening. Okay. True story, we have heard of a judge, once the judge learned that there was a need for an interpreter, telling the bailiff to run down to the local Mexican restaurant and grab somebody. And you go, okay. And this is where we have this very big misnomer that the only skill that you need to have in order to be an interpreter is bilingual. And the U.S. Department of Justice has been very clear that mere bilingualism is not enough, that there is more skill and training that is needed, because just because you are bilingual does not mean that you know how to interpret. And we all know as lawyers and as aspiring lawyers and judges that legalese, that's a whole nother language. Sometimes English is my first language, and sometimes I don't know what things said, and I have to read it over and over and over. And so being able to be conversant in a language and just have general lay conversation and being able to maybe sight read a brief or talk about legal jargon or terms of art for your particular practice area, that's a totally different story and requires skill and training. We talked about earlier, Pilar was doing a consecutive mode of interpretation. There are three main modes that interpreters are taught. Consecutive, where the person will speak, they take a pause, and the interpreter will interpret in phrases. And generally you will see that with witnesses or just in general conversation. The second most common form is simultaneous, where they're speaking at the same time. And most of the time you will see, that's the one you see with witnesses, excuse me. Consecutive, the phrase by phrase, you see that more with judges as a form of deference to not be talking over the judge or at the same time. The last is sight translation, where a piece of paper may be given to the interpreter while it's there, and they're asked to translate that. And one point of mention, I've been using the term interpretation a lot, and I know sometimes we say interpreter and translator interchangeably, but they aren't. Interpreter or interpreting is when you are providing interpretation verbally. So from the source language, which is the language of the person. So for me, my source language would be English, and then interpreter will then will interpret that into Spanish or French or whatever it may be for my client. And because it is a verbal exchange, that is what is referred to as interpretation, which is done by an interpreter. Translation deals with written material. So if you have a document that needs to go from English to Spanish or Spanish to English, then you are getting that document translated by a translator. And so we use those terms very specifically when we are speaking about those issues. But getting back to Rule 1.7 and the conflict of interest, the conflict of interest comes in because the role of interpreter and the role of attorney, those are largely antithetical. An interpreter, on the one hand, is neutral and impartial. They have an ethical duty to be neutral, to be impartial, and to interpret accurately and competently in that realm. An attorney, on the other hand, we have an ethical obligation to take a side, to represent our client's interests to the best of our abilities. So we are not neutral. So again, that's how we look, and that's another reason why you're not able to serve as both an interpreter in your own case, and also the attorney. The other big thing that we want to look at with bilingual attorneys as well, and some courts will rationalize and say, okay, well, this attorney, they're an officer of the court, we can trust them, that's okay. Unless that attorney is licensed as an interpreter here in Georgia, they shouldn't be interpreting. That should be a very last resort. It definitely shouldn't be their own case. There is a statewide registry of licensed interpreters. We have 3 licensing designations by the Commission for our interpreters here in Georgia. The most highly skilled are our certified interpreters. For those who don't quite test as high but have demonstrated that they do have adequate skill to interpret, they have a conditionally approved category. And then we have a registered category for our languages that have no national certification exam. And those are our more rare languages. And so according to the Supreme Court rule, which is in your materials, the court has a duty to first try to appoint a certified interpreter. If and only if a certified interpreter is not available and it will cause more harm to continue the case than not, then they can look to see if a conditionally approved interpreter is available, and then they go down the list. But there's really a strong emphasis to use a certified interpreter, and at the very least, an interpreter who is licensed by the Commission. Okay. So those were the main rules that we talked about: 1.0, 1.1, competency, 1.4, communication, their confidentiality, conflict of interest. We briefly also mentioned to the ABA, there's this question about fees. And that's the part where it gets practical. We talk about all this and it sounds great, and if I could just wave my wand, everyone would be able to afford what they need, they would get an interpreter, courts would be able to have what they need, but that is not reality. And so we talk about fees. Who pays for it? How does an attorney assess? Is this something that they put into their billing? Is their client having to pay for their own interpreter? We need guidance on that. We don't have any guidance. It's very clear when you go into court, the court has an obligation to provide that interpreter, but courts still have the same questions. They go, hey, you all are telling me that we have this obligation, but where do we get this money from? And so that is a challenge that we are working on with courts to figure out how do they comply with Title VI for those who are having those fiscal constraints. And there is no clear answer. And so there is guidance that is needed, not just from the ABA, but just generally with addressing that issue in our courts. Meritorious claims, bringing meritorious claims. What happens when you're bringing a claim and you're not aware of what is going on in the case? Is it meritorious to bring a claim against someone who doesn't understand what is going on? We see this a lot in consumer cases where the defendant who's being sued for a suit on account for an allegedly delinquent credit card, all of their documents, they're being served in English. However, we know the creditor is aware that they possibly don't understand English that well because there are printouts of bank statements or credit card statements that are in that client's preferred language. So we think about that. What relation is there between meritorious claims and representing limited English proficient individuals? 3.8, prosecutors' duty to ensure procedural fairness. And in my experience, and I know it's different in different things, but most DA offices and Solicitor General, they're aware of the obligation to provide interpreters, particularly because it's in criminal matters, and in criminal matters, liberty is at stake. And again, the Ling v. State case from 2010 from our Supreme Court made that very explicit about the duty to provide interpretation, and in that context, it was a criminal context. And so For the most part, I think our courts are very clear in the criminal context there. 5.3, that was from one of our earlier hypotheticals about, no, not the hypotheticals, from one of our earlier examples, I believe that was from Washington, about supervision of bilingual staff or third-party language service provider. I was just at a very great workshop the commission had on this last Wednesday, and the interpreters one of the certified interpreters was giving a presentation, and he reminded the audience that interpretation requires 3 people. And so if you were an attorney who was using an interpreter, and one of the scenarios that he gave, he asked the interpreters, he said, if you're in court and an attorney walks up to you and says, hey, here's a piece of, I have this document, can you please explain it to my client, I'll be right back, what do? The court has appointed you, you're supposed to be there, the attorney walks up to you and gives you a piece of paper, what do? Well, the interpreters, for them to maintain their code of professional responsibility, they can't do that. They can't speak to the client outside of the attorney's presence. That's not interpreting. That's the interpreter explaining a document which is bordering on unauthorized practice of law or giving legal advice. Just like our clerks and our clerk of court, they are not allowed to give legal advice. It's the same thing for the interpreter. The interpreter is strictly there to serve as a communication medium. And so that requires the 2 main parties to be there to converse with one another, and it's almost as if the interpreter is removed and they're just kind of like a ghost, just there providing the interpretation services. So where do we go from here? What do? We don't have commentary in the rules that speak to these particular aspects. There are opposing opinions that, and there are opponents who say, it's not my job to provide the interpreter. And the response that we got from the ABA, which it was interesting, they said, we agree with your analysis, but everyone on the committee was saying, well, duh, this is common sense. It's common sense that if you have a client who needs language assistance, that it's your duty to help and to make sure that they understand. And so we kind of said, well, the commentary and the guidance isn't for the folks who are on the panel. It's for the attorneys, who may not be their view, or they think it's okay to not provide that instance. And so we are working to see how we can get this guidance and provide it, working at state levels. There are various states across the country that are working on it at the state level, working with their disciplinary panels and general counsels to address these issues. Because when we were doing research to submit the letter to the ABA, our group had an opportunity to talk with a number of disciplinary counsel from across the country. They said, yeah, we actually are seeing a proliferation of cases that involve communication issues with limited English proficient clients or witnesses or whomever. So based on that map that I showed you all in the beginning, we see that the population is steadily growing based on that last census from 2010. The trend is continuing. And so if our national LEP population is growing, then it just stands to reason that there are going to be more individuals that are in need or that we're going to come in contact with as lawyers who English may not be their primary language, and we're going to have to figure out a way to be able to provide competent services to those individuals. Do we have any questions? I know I'm right on the cusp there. Any questions at all? Okay, yes.
Or no?
Yeah.
Yeah, okay. Is about whether meaningful access to the courts for LEP persons means getting translation not just of direct questions to them and the things that they say to the court, but actually things that are said as part of the court process around them by witnesses, between an attorney for the government and the judge, between their attorney and the judge, and so on. When I used to practice in immigration court, it drove me nuts because the only thing that would be translated were direct questions to my client, and so he or she would be sitting there for a huge amount of time with all kinds of things happening, and I would ask for simultaneous translation of everything, and usually only get it for a short period of time. And so I'm not familiar with the state court practice in Georgia, but to me it always seems like you're not really getting meaningful access to the process if you're not getting everything or nearly everything that is translated so that you can potentially respond to that or advise your attorney about it.
Yeah, and I know, federal courts, they're a different animal. They have, in they're federally, there's a different certification level for someone to interpret in federal courts, and so there are different standards that are there. But generally, particularly, when we're speaking in Georgia and state courts, interpreters are interpreting everything that is going on. So it's, if the judge is making a comment to opposing counsel or making a comment to you, and it happens to be your client who's LEP, the interpreter should be interpreting all of that. And technology has also come a long way in a very short period of time, where now sometimes you may see, instead of the interpreter having to physically be right next to and whispering in the LEP individual's ear, that they're able to use kind of a headpiece, and you may see the interpreter sitting off to the side or way in the back or just somewhere else, and they're able to listen, and they speak into a microphone, and so it's less invasive that way, and they're able to do it, and that's helpful. That also goes back to the team interpreting as well. In some courts, they will employ an interpreter for the litigants, and especially if they have that technology, so they can easily do for both. And then there's an interpreter for the courtroom, and that interpreter for the courtroom is the individual who's interpreting for the judge, possibly for the state or whomever. So really, it just depends. But at the core of the Ling v. State case, the Supreme Court talked about language access is about you have a right to participate in your legal representation. And participation requires you to be knowledgeable and understand. And if you cannot understand what is going on around you, you are unable to participate in your case at the level that you are, are supposed to be able to. And so we think about those things when we think about what is the level of interpretation that is going on. There's someone over here that had a question. Yes, sir. Or electronically. Georgia currently now is testing some remote interpreting. We have a pilot remote interpreting project going on, because one of the challenges that we see when you're in Metro Atlanta, it's a different story than when you're in more rural parts of the state. Even for a Spanish language interpreter, they're just not as available and accessible. And then don't you dare get into the more rare languages or indigenous dialects when you're in different parts of the state. And so how can we help to bridge that gap and not have to rely on an interpreter from Atlanta driving 6 hours down, which that gets into the cost for the court, because interpreters are not just billing for their actual time when they're in court, they also bill for their mileage. When a calendar call is at 9 o'clock and your case doesn't get called for until 11, that interpreter showed up at 9 o'clock, so they're being paid from the court beginning at 9, even though your case may not go until 11 or 12, and so the court is absorbing those costs. And so remote interpretation is a great tool and it's a great resource, but there is no substitution for having an in-person interaction, because interpretation is not just about interpreting the language, but part of providing an accurate and a competent interpretation is also the body language and what is said. So just think about if you have a litigant who is very somber, if we're talking maybe about a domestic violence case, and the victim is giving their account of their assault, and their mood may likely be somber or sad or just very emotional, and you have an interpreter who is happy-go-lucky and they're giving it, that is going to alter how the jury or whomever is perceiving that interpretation. And so it's when you're able to connect with the person, they're physically there, it just provides for a better experience. But I do think that the technology, to answer your question, it is going to increase. We will have an opportunity. And one of the resources that Judge Clayton mentioned earlier with the commission, if there is a language for which the commission does not currently have a licensed interpreter, you can call the commission and they will help facilitate in finding an interpreter in that language. That interpreter may very well be in another state, so they may, they may have to be flown in. It may be someone who is, who can be remotely accessible, and they will do a video conference. But in the success rate with the commission being able to find the different languages is very high. And I know the National Center of State Courts is also working on creating a national database of all the interpreters across the country that have been professionally trained, so that states can very easily look on a very master list. Right now we have a statewide list, but they're hoping to be able to roll out very soon a national list that we will be able to access and get the assistance that we need. Yes, ma'am.
Right now, there's only one officially approved Korean language interpreter in all of Georgia. There's over 120,000 Korean Americans in Georgia. So I don't really know how the disconnect is happening between, training and finding the qualified interpreters to live with consumers. I understand it's quite difficult to get educated.
It's,
What's the stopgap? Are you using language lines, and
Yeah,
there can't just be one?
right.
those are the kinds of things that we have problems with. I mean, sometimes we do have to use language lines, but I absolutely hate that. I don't even like to have a phone conference where everybody speaks English. I like to be able to see the people that are in front of me. But that's part of the problem. But yes, part of the difficulty, if you read these rules, you'll see, or the materials, you'll see that right now there's no uniformity even about how interpreters are paid, about how much they're paid or anything like that. And the test is very, very, very hard. I will tell you that I have a niece who was a Spanish major in college and studied in Spain and Cuba as part of her college education, and was unable to pass, and worked in the court system, and was unable to pass both parts of the exam. She was able to pass one part, but not the other part of the exam, and she is extremely proficient in Spanish. That's not what she wanted to do for her life work. She was just going to do it temporarily while she was going to school to become a nurse. She's now a registered nurse. But there's no profession of interpreters yet. Maybe when we get to the point where where we have some uniformity about that it pays enough that people will work enough in this to get trained enough and spend the time and the effort, we'll have more people in the more difficult languages and the more inaccessible languages. But for right now, we have to use the language lines and the things like that.
And also echoing Judge Clayton's sentiments, and to get some context, the national pass rate for certification exams for interpreters is 4%. And the pass rate here in Georgia for the tests that are administered here is on par. It's usually about 4%. And that is with native speakers, people who are in it. So the test is difficult, but when speaking with certified interpreters, and we ask, well, should the test be made a little bit easier? They say no, because what is required to pass that examination is what you want. That is who you want in the courtroom providing interpretation. So the exam is very difficult. There's a written component, there's court observation, the process rather. There's a written test that you take in English with idioms and slang and some other court jargon, and then there is an oral part in both English and in the target language. But one of the challenges that we do see, was going to your question about the fact that we have such a very substantive number of individuals from varying communities and populations, why aren't there more interpreters, I think goes into our recruiting, and why aren't folks why aren't they signing up to get this training to provide? Some of the challenges, it is the expenses of going through that process, so that may impede some people. They may not have the funds to go through and pay the money that is there. But we are actively searching and always recruiting for individuals who do have language skills to sign up to go through the process and become interpreters, because, I mean, we need them, and we need more diversity amongst our interpreters. Spanish, I think we have covered in terms of number, but that's here in the metro Atlanta area. If you go to different areas of our state, it's very difficult to get a Spanish language interpreter, even though that's our most difficult. And there are quite a few supportive. There's NAJIT, the National Association of Judiciary Interpreters and Translators, and so there is a profession out there for interpreters and professional, support. But there's still quite a number of challenges that we have to address at the state level. And like I mentioned earlier, part of that challenge is we are not a unified court system, and so it makes it a little bit different how we're going to address those issues. Thank you very much for your time.
The preceding program is copyrighted by Emory University.